Thank you so much for watching Law School Made Easy at Law School Made Easy 256. In this video, we are going to discuss the law of tort, and we are going to discuss negligence, rescue situation, product liability, nervous shock, res ipsa, loquitur. We are going to discuss skillful professionals, and then we shall discuss death as a cause of action. We're going to summarize both of them, all of them, just to help you understand what you are supposed to read, how you are supposed to go about all these topics that I have mentioned. I want to repeat in this video, we are going to discuss the law of negligence, and in there we're going to discuss product liability, rescue situations, nervous shock. We are going to discuss skillful professions. We are going to discuss the concept of res ipsa, loquitur, and finally we shall discuss the concept of death as a cause of action, and we shall call it a wrap for the first bit of the tort law. We thank you so much. So let's go to the law of negligence. Our colleagues, in the law of negligence, when they ask it, there are two things you must know: that negligence has existed for ages, but prior, negligence only existed under what we call contractual obligations. That when someone became negligent, it was due to the contractual obligation that existed between the two parties. Now, where we don't have a contractual obligation, it meant that negligence would not arise. So you can now stress it from the case of Winterbottom versus Wright, and then you come to the case of Heaven versus Pender, and in the Lodridge case, you explain that negligence to occur, there needed to be a contract. Then when you get to 1932, when we have the case of Donahue versus Stevenson, now this case modified the present day negligence that we have. The present day negligence was modified by the case of Donahue versus Stevenson. In this case, of course, the facts of case, we have done the video about the facts of the case. You can go and check the facts. But in this case, Lord Atkinson stressed a few points. One, he stressed the neighborhood principle, that the law that love your neighbor as you love yourself. So in law, what do we mean by loving your neighbor? Your neighbor is someone who will get affected because of your actions. So therefore, he set out clear principles. Number one, that for negligence, that the negligence can exist even where there is no contractual duty, but because we have the neighborhood principle, therefore he said there should be a duty of care, there should be a breach of duty of care, and there should be injury or damage. That negligence can arise under those three circumstances. That if you fulfill the three elements of negligence, which is duty of care, breach of duty of care, and then injury or damage, that if somebody has a duty of care and they don't perform it, but they breach the duty of care, and then their breach of duty of care causes what we call the damage or injury, then someone has acted negligent. Now you can see we are running away from the scope which used to say that for negligence to occur, there must be a contract. If you look at the case of Donahue, you will find that there was no contract between Mrs. Donahue and Stevenson. There was no contract, but the case succeeded. However, not. It was a series of events. There were almost three cases, and the last one is the case we are using, Donahue versus Stevenson. So therefore, we are saying that when discussing negligence, first bring it from that perspective, that first it was contractual obligation, but now we have the three elements of negligence. Now, after discussing that, there are two other important elements of causation and remoteness. Now, when you want to determine causation and remoteness, it's very important because this is going to be the basis for you to be able to award the damages or not to award the damages. Now, causation means that you must draw a link between the injury. You draw a link between the injury that has been caused and the breach of duty of care. You first establish that, yes, did this person have a duty of care? Yes, they had a duty of care. Now, if their duty of care was breached, was the injury as a result of the breach of duty of care? Yes. The moment you establish that, it means that you have been able to successfully establish causation. Now, when it comes to causation, to remoteness, colleagues, when discussing remoteness, two elements should be in your head: directness and then reasonable foreseeability. At the moment you're talking about remoteness, you're now going to go back and look at the situation. Is the injury as a result of breach of duty? Is it direct? If it is direct, that the breach of duty of care caused the injury, then it means the injury is not remote, because it is the duty of care, the breach of duty of care, that directly caused the injury. But again, we can foresee the injury when determining remoteness, reasonable foreseeability. How do we say that the injury was either foreseeable or it was not foreseeable? If the injury was foreseeable, then the damage is not remote. But if the image was not foreseeable, then their remoteness of the damages, somebody is likely not to get any remedies because the injury is remote. I'll give an example. Look at the case of Bohill versus Young, where Mrs. Bohill had an accident, and then by the time she reached the scene, even the dead body had been taken away. There were spits of blood all over. So because she saw the blood, okay, she got a miscarriage. Okay, and now she's suing for damages that she has suffered under nervous shock. Now, here, she cannot get damages because it is too remote. It was reasonably unforeseeable that hearing an accident can cause a miscarriage. So there is no direct link of the injury suffered by Mrs. Bohill and the event that happened. So in that way, she cannot recover. But where, let's assume that she was involved in the car, or she was knocked by the car herself, and then she gets a miscarriage, then there the damages are not remote. There she can be able to recover. Hope, colleagues, we have understood the difference between remoteness and also causation. But if you want to discuss remoteness, there are two cases that you can use when discussing remoteness. One of them is Bohill versus Young, and another case is Turkish UK versus Mutz Dock Company. Mutz is M-O-R-T, Docks Company, which many colleagues call Wagon Mond 3, Wagon Mode 1, Wagon Mode 2 and 3. That is the case. Turkish UK versus Mutz Docks is the case that you will use when describing what we mean by remoteness. So, colleagues, now that we have established the elements of negligence, now, under negligence now, duty of care, we have used the case, you can use the case of Ans versus Metron, Metro Borough Council, or duty of care still, you can use the case of Caparo versus Dickman. Now, these two cases established principles. They expect you, when discussing the breach of care, if you use the case of Ans Metron, you have to bring out the element of proximity. And also, they discuss the elements of the years which the council had, the years which the building had spent vis-a-vis the time when it was constructed. All those elements were brought out. But the issue is, you must establish duty of care. That you cannot just come and say, I am going to discuss duty of care and then you are very flat. No, establish it. Now, if you're saying, I have a duty of care, is there a proximity? Is there a relationship between what has happened and me who has caused it? You must establish. Certain times, another element would be reasonable foreseeability. That you, for example, if you're a manufacturer, did you reasonably foresee that making a good with defect would cause these such problems? Those are some of the elements which govern. Secondly, there should be just and fairness when establishing the duty of care principle. So look at the case of Caparo versus Dickman. Look at the case of Ands versus Metron Borough Council. In those two cases, you'll be able to establish the elements of duty of care. So colleagues, let's now cross to another subtopic under the law of negligence, and that is product liability. Colleagues, when discussing product liability, these things are very important. One, you must note that product liability is as a result of duty of care and breach of duty of care. You must explain the neighborhood principle that governs manufacturers, that as manufacturers are making their goods, they should take reasonable care. They should take reasonable care because they have a duty of care to protect their neighbors. So the Locus Classicus case under product liability, colleagues use the case of Donahue versus Stevenson and very many other cases. One, you must establish that what happens to the manufacturer if the manufacturer manufactures goods and they leave their factory with a defect. What happens if the manufacturer manufactures goods, but in between there are intervening factors which make the product to have defects along the way? Now, you must draw that distinction. Then, what happens if there are defects in manufacturing? And what happens if there are defects in design? Colleagues, let's look around these areas when we are trying to appreciate and discussing the concept of product liability. But all in all, product liability is about duty of care. They are saying a manufacturers owes their neighbor, and in this case their neighbors are the consumers, a duty of care. When they breach their duty of care, they are going to cause the damage to the other people. So hope those there are very many cases. Hope we can look at product liability in that way. So let's go to what we call rescue situations. Rescue situations. Colleagues, key elements to take home when discussing rescue situations. Number one, we are dealing with professional rescuers. We are not dealing with anyone, but we are dealing with professional rescuers. Where that problem question indicates that the person who rescued is not a professional rescuer, then that one, the laws of rescue situation does not apply to them. Have that at the back of the mind. Then also, we are discussing the duty of care under rescue situation for the rescuer. That we are protecting, the law is protecting the professional rescuer. That as he comes to rescue somebody, there should be reasonable care offered unto him as he's doing his job. So that is the basis. The rescuer is one that the duty of care is applying to, not the rescue. Hope we are clear with rescuer. The Locus Classicus, or one of the leading cases of a rescue situation, is Wagner versus International Railway Corporation. That is WAGNER, Wagner versus International Railway. Read that case where a train didn't close very well the train, and one of the passengers fell out. The brother moved 445 steps trying to rescue him. He also got an issue, and then the matter came before court. So that is one of the leading cases in rescue situation, but not. We are discussing the duty of care to be to the rescuer and also professional rescuer. So look at this topic in that perspective. Hope we are of hope in that line. But we urge you to subscribe, to share and like our videos. Let's go to nervous shock. Colleagues, nervous shock is looked at in two ways. We have the primary victims and the secondary victim. When discussing the primary victim, they are telling you that these are people who are affected and they are at the scene. They are involved. Look at Page versus Smith. Page was involved in the accident. That these people are involved. They are at the scene. That until the case of Alcock versus Alcock versus Yorkshire Police, Constable Police, something, until the case of Alcock, nobody would recover from nervous shock if you were not a primary victim. That you should have gotten the injury yourself. You should have been involved in the event that caused the nervous shock to you. Then, colleagues, let's cross to secondary victims. That after the case of Alcock, principles were established that even secondary victims can now recover. That even when you are not involved, but you are watching from television, you are near where the event is, then you can be able to recover. And therefore, secondary victim, there has been principles which have been set, or elements. Number one, love and affection. That you must prove that the people who are affected, we have close ties of love and affection. Failure to prove that, then you cannot recover damages under nervous shock. If you're a secondary victim, again, you must prove proximity. You and the distance where the event happened from, where the accident, were you so close? That way you can be able to recover. And then reasonable foreseeability, that maybe there was reasonable foreseeability of the event that this would happen. When you prove those elements, you can be able to succeed under nervous shock. Let's look at the case of McLean versus O'Brien to clearly explain what we mean by secondary victims. The case of McLean versus O'Brien. In this case, colleagues, a woman was told that his whole family had got an accident, and she went there. Then she got nervous shock on finding them mad with blood. One of them had even died. So she recovered damages because she was a secondary victim, and she was able to prove the test of love and affection, that these were my family, my husband and my children. Then she was able to recover damages under nervous shock. So now let's cross to another topic, and that is negligent word misstatements leading to financial losses. There are three cases. Maybe let me give you cases of nervous shock that you can go and read and you come and apply. Page versus Smith, Bohill versus Young, Alcock versus Yorkshire Police Constable, Caltas versus Victorian Railway, White versus Join, the Halloween case. Sorry, Frank versus White, something. Yes, the Halloween case, and very many other cases that you can use in nervous shock. So let's go to what we call negligent misstatement leading to financial loss. Let me tell you, under negligent misstatement, we are discussing three serious cases. There are very many other cases, but kindly focus on Headley Brain versus Heller as one of the locus cascas cases for negligent misstatement. Focus on Capallo versus Dickman, another locus cascas case, and also focus on Derry versus Peak. These are leading cases in negligent misstatement. What do we mean by negligent misstatement? We mean that people utter statements, and those statements, when relied on, they cause financial loss. Look at Dickman versus Capello v. Dickman. That, yes, whereas Dickman's case never succeeded, but the issue is Dickman made accounts, but he never knew that somebody was going to rely on them. That is why he was exonerated, because he never knew that somebody would rely on the accounts that he had made. But the Capellos relied on them and made financial losses. So we are saying that under negligent misstatement, discuss the economic loss, discuss the fiduciary relationship. That if you are under duty to advise, then advise. If you are accountant and client, advocate and client, advise very well, because when you fail to advise your clients well, the way it was in Hede Brain versus Hela, then it means you are going to cause financial loss to those people. So hope we are okay with the negligent misstatement. That is how you read and appreciate in that concept. So let's go now to what we call skillful professionals. Specifically, we are going to discuss medical professionals. Now, colleagues, it is kind of disturbing when it comes to medical professionals. Now, here they mean that the skillful people are supposed to have a duty of care to perform their duty, because failure to perform their duty, that is a breach of duty of care, they are going to cause injuries to people, yet they are professionals. But there is an exception for doctors. If the doctors perform their due process, if they do what is supposed to be done in their professional conduct, then they cannot be held liable. Meaning that if they work on you and they do all the procedures as they are supposed to be done, then even if you die, then they cannot be liable. Because if it was the case, meaning that people even fear to become doctors, because if you work on somebody and they die, then you are held liable. But for doctors, it is made very clear that for us here as doctors, if we do our part and then you fail, but for as long as we have done our part, no doctor can be held liable for that. Take note of that. There are many cases, colleagues, that we can use under the medical practice. But if they perform their duty well and they negligent, for example, forget gauze in your body, forget an equipment in your body, then there we shall hold them liable. There are many cases, colleagues. Look at the case of Barnett versus Chelsea Hospital Management. Look at the case of Bolam test, the Canterbury test. All those tests, Injericator is a locus classicus. It can explain to you the idea that they cannot be charged because Injericator had come to cut he had said they cut his leg, and then he changed, but the doctors went ahead and cut, and he was awarded one nominal damage, meaning that the doctors were not in any way reprimanded. So that is how you go about the skillful professionals, that all skillful professionals have a duty of care. When they breach it, then they have caused damage and they will be held liable. But where they are doing their job, especially the medical practitioners, they cannot be held liable if what they have done is the rightful procedure without any mistakes. So we can now cross to another topic, which is ipsa loquitur. Ipsa loquitur, which means that facts speak for themselves. That facts speak for themselves. Colleagues, that there is nothing else you can say. From what we are saying, you are the thief. Now, there are three elements you must prove under ipsa loquitur. Colleagues, there are three elements you must prove under ipsa loquitur. Number one, you must prove that the act which happened was as a result of negligence. Number two, you must prove that the act which happened as the involvement of the defendant that happened as a result of the defendant's conduct. And also you must prove that the plaintiff has nothing to do with what happened. That the plaintiff has nothing to do with what happened. Colleagues, I want to repeat. If you're discussing the ipsa loquitur, a maxim which means that facts speak for themselves, there are 3 elements you must prove. The moment you prove them, then we are good to go. Number 1, you must prove that whatever happened was as a result of negligence. Number 2, you must prove that whatever happened has the involvement of the defendant. The defendant is involved in what has happened. And 3, you must prove that the plaintiff has nothing to do with all that has happened. So that is what we mean by ipsa loquitur. You prove those ones. I'll give an example to explain what we mean by ipsa loquitur. You assume you are in your compound. Maybe you stay near by roadside. You are in your compound, you are cleaning early morning, and then a car comes from that side, driving recklessly, and then he comes and knocks you, and maybe you die. Or you don't die, but you get injuries. Now, the ipsa loquitur comes in. The accident was as a result of negligence. He was driving recklessness. That is 1. 2, it is the defendant who caused the accident. There was a driver who was driving, is now the defendant. And you, the plaintiff, you have nothing to do with what happened. You were cleaning your home, and before you know it, you had a boom, you are being knocked. That's what we mean by ipsa loquitur, that all facts speak for themselves. That there is nothing you're going to tell us. You caused the accident as a result of negligence, and the plaintiff has nothing to do with this, and therefore you are liable. So that's what we mean by ipsa loquitur. And finally, colleagues, we shall discuss what we call death as a cause of action. Or we can have death as a cause of action in another video, because it's a bit, we need to elaborate it, but let me take you through briefly as death as a cause of action. Colleagues, death as a cause of action means that we are starting an action. Cause of action means one way of starting an action in the courts of law. So mean that it's under civil law, we are going to start an action as a result of death. That's our colleague died, and now we are starting an action. There are 3 elements to prove under death as a cause of action. You must prove that there was a duty of care owed to the deceased. That duty of care was breached, and then the deceased died. 3 elements. That there was a duty of care owed to the deceased. You must prove that. And that breach, there was breach of duty of care which led to the death of the deceased as the 3rd one. The injury in this case is the death of the deceased. Now, you must prove those things. That you are supposed to drive well on road. You have a duty of care to make sure that you reach safely, and also all people around you, your neighbors, will be affected by your actions. Now, when you breach that duty by overdriving, by driving reckless, you breach it and then you knock somebody, they die. So we come and start an action in courts of law. Now, why do we start these actions? We start this action, 1, of course, for justice. 2, of course, we want to now see how are the dependents who are staying behind, how will they benefit? Of course, they're not benefiting from the death of their breadwinner, but we are saying that we are not going to leave those dependents hanging, yet you negligently caused the death of their breadwinner. So we start an action. And now there's what we call the multiplier effect under death as a cause of action. How do we calculate what you are supposed to compensate the people who lost their beloved one? So when we get to there is what we call the dependent syndrome. Now, meaning that if the deceased, for example, is 50 years and the life expectancy is 60 years, we subtract the 50 from the 60 to have 10 years, meaning that the deceased was going to stay on this universe for another 10 years. And meaning that while he still stays for 10 years, he was going to take care of those dependents. Now, we calculate what was his expenditure on the dependents. Let's say 10 million. So we say 10 million times the years which are remaining, and then we get 100 million. So they will charge you 100 million, and that money will go to the dependents. But note, when we have dependent, everybody, for as long as they are depending on the deceased, they will get something. But the people who take precedent are the children, because solely the children have been depending on the deceased. So meaning for them, they will take a bigger share because they are the children. Two, the spouses will also, because they've been taking care, they'll be depending on the deceased, they will take. Then there are other spouses, girlfriends, who were depending on the deceased for a particular activity, maybe tuition, maybe food, maybe if they were solely depending on the deceased, even when they are not married, legally married, they'll have to get that share which the deceased was taking care of them. Then the others, fathers will come in, but that is the order. But everybody who is depending, and when discussing this, we don't calculate, we only write them verbally. We say that this one will get because of ABCD, because he was depending, he was a child, is a wife, is this. That's how you keep on explaining. Locus Cascas case, Dibia versus Uganda Electricity Board. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our video. Until next time, thank you. Cheers.